First, I want to introduce myself. My name is Ryan Andrews. I'm the Chief Judge for the Salt River Pima Maricopa Indian Community. I'll be moderating the session today, under the court clerk track, the practical advice for tribal court clerks. Today we have the Honorable Gregory Bigler and Ms. Donna Beaver from the Muskogee Creek Court who will be presenting today. So they'll be going through their PowerPoint and stuff. So in my understanding from the moderators, you can go ahead and ask questions, but when you ask questions, make sure that you speak up because they're going to need to, because they are recording, they're going to need to be able to repeat them. So they need to make sure that they can hear you, and they're going to be kind of be confined to up here. So again, if you can just speak up, we appreciate it. So I'll go ahead and turn the time over.
Mado Senlangasada. Thank you. We've had some technical difficulties as usual. It's just like in our court where we always think we're ready to go, and then of course our recording system crashes. So I'd like to begin with something here. Gashtali Aheiha Gojisla Shachwane Wekam Gatlade Jen. A long time ago when they all used to be here, they used to tell this, that Gojithla, or monster, was going around eating all the other little animals. And so all the animals had gathered together and had met and to discuss what they were going to do about Gojithla. Now, at that point, they were concerned. You know, they didn't like what Gojithla was wandering around. And so they decided that they had to take care of this, resolved that someone had to go and kill Gojithla. But Gojithla was pretty ferocious, fearsome. So Sage Bear had, when they'd asked who was going to do it, he kind of sunk down and looked the other way. And they thought that maybe Wolf would be able to do that. And someone said that, but they couldn't find where Wolf had gone off to. And so they looked around, and so all the other animals would just look in the other way, wouldn't speak up or do anything. But Shachwane, that's Rabbit, was sitting there. He was sitting next to the pretty girl. And of course, he was flirting with this girl and trying to look impressive, and everybody else was being quiet and looking the other way, and this girl was saying, "Oh, isn't there anyone that's brave enough to take care of Gojithla? Isn't there anybody here that could be our hero and take care of this?" And so Shachwane really wanted to impress this girl, so he jumped up and said, I'll do it. And so they're all excited, and he did not realize what he had committed himself to doing, going after Gojithla. But then the old people used to tell this and go on with that story about his adventures as he went off to take care of business there with Gojithla. Now, I tell that story because this is an old Yuchi story, very old. This comes from a long ways back and has a lot of things in it. But part of what it does is, although it's what we call in Yuchi, called a di'ile, and you might call it a legend, you might call it a children's story. A lot of those old people would just tell this to each other when they're sitting around. Those type of stories, they're not used so much anymore. But we used to tell those stories a lot. But in this particular one, if you think about it, like I say, it's just a kid's story, you might say, in a way. But if you think about it, there's a problem within the community. Gojithla is violating the standards of that community by going out and killing other animals. And so all the animals gathered together in council to discuss the problem. And they decide upon a resolution. Now, with our people, I know that we talk a lot about peace and harmony and restorative justice, but Yuchis, we believed in retribution and blood feud. And so they had decided that Gojithla had to be executed. And then they appointed someone to carry forth that sentence. So, although it's a children's story, it also shows that we had dealt with troubles, we had dealt with problems, that we had a way of resolving them, and that we had things that we would do to take care of it. And if anything, that's simply what we as courts do. The fundamental purpose of a tribal court, of any court, is is to resolve disputes in one way or another. Now, after a little while, we're going to have my clerk from the Muskogee Creek Nation, Donna, come up here and talk about some of the details of the everyday types of procedures that she uses. Originally, I had prevailed upon her and the clerk over at Sac and Fox Nation to do this same presentation at our continuing legal education about 2 years ago. And that's, of course, primarily to attorneys. But when we have these CLEs, the continuing education, so much of it goes towards the law, the jurisprudence, the case status, and so forth. But another story that I think I remember and took to heart when I was just straight out of law school. I graduated from law school in '85, and I had a fellowship at Madison at Wisconsin Law School for the year after that, graduate law fellowship. The first day there, I got to the law school and was shown my little cubicle, my workspace. And then one of the people took me around to meet the different departments and other professors and show me where the library and all the different facilities were. Towards the end of the tour, they said, "Lowell, let's go up and meet the dean. We'll go to the dean's office." And so we went up there, and the dean wasn't in, but his secretary was. And I thought she was old at the time. She probably wasn't as old as I am now, but at that time I was a young kid. She seemed old to me then. And she was really nice. We visited for 5-10 minutes, and she told about the history of the school and the professors and the dean and, some other things. And as we're about ready to leave, she turned to me and said, Now, honey, if you ever have anything you need, you come to me. Because I've seen deans come and I've seen deans go, and I'm still here. And I tell you, that was advice that I have taken to heart. That's the flip side of my other saying, is that the clerks are always right. If you have an attorney that does not understand that, they are not going to be very successful in the long term. So with that said, sometimes as attorneys we forget. I've practiced in the field of Indian law for better part of 30 years. My partner was very successful at that. We did a lot of things together for the many years together. Sometimes we forget how much we have kind of learned over a period of time about tribal law, Indian law, tribal procedure, federal procedure, and so forth. As I said, Donna will get into some of the particulars, and maybe just by talking about it out specifically, it'll bring forth some thoughts for you, ability to contrast and compare how you do it, maybe some insights, create a dialogue so that hopefully it's helpful. But for me, I want to do part of what I did yesterday for those who were the judges. I assume that it looks like it's mostly a different audience today, the clerks. I assume that almost everybody in here is a clerk working in the field. But I want to give kind of a background of how it is and why it is that we exist as tribal courts. So that overview includes some of the questions of what is jurisdiction, what is involved there, the historical development of these tribal governments, tribal courts, and then maybe some other particulars. And of course, jurisdiction. As tribal courts, one of the things that both exciting and frustrating in working in tribal law and tribal courts is that we have all kinds of stuff come up. I know that the tribal courts can vary in size. Our tribe at Muskogee Nation has about 80,000 members. Just to the east of us is the Cherokee Nation with 300,000 members. There are tribal courts that have probably, some tribes have members of 80 people or less total. Some tribal courts I've worked with may meet once a month with just a couple cases, and some tribal courts probably meet maybe every day, 3-4 times a day, have very full and extensive dockets, so it's all over the place. But we also have to worry about not only what we are hearing in our court, but we have to worry about the state courts and the federal courts, because the state courts are trying to take things that belong to us, and the federal courts are going to be looking at us with very close eyes in many instances. One of the things that I have been doing the past year much more consciously and much more actively is involvement in the international arena of the United Nations Declaration of Rights of Indigenous Peoples, which was adopted 10 years ago by the United Nations. It's a fairly legal reading document. Some of you are familiar with it. It's got about 43 articles in it. But the most important thing in there is that Article 3 says that indigenous peoples, or for us Indians, have an inherent right to exist. That means that only we get to say whether we continue on or not. Not the United States, not Germany, not Canada, not wherever you happen to be. That is not the current federal law. Under federal Indian law, the U.S. Supreme Court says that they can terminate our existence at any time they want under the plenary powers. And that's happened to some tribes you may know of. My wife's tribe, Menominee, were terminated back in 1954, I believe, and it was a 20-year process of fighting to reestablish the federal recognition. 123 tribes were terminated back in the 50s because the federal government was getting out of the Indian business. A few of them managed to be re-recognized or establish that federal recognition. Many of them did not. That could still yet happen at any time. So we have to worry about these things in a broader sense. Maybe not in our day-to-day stuff, but so we have to be aware of that stuff, those things. I think that what I tell people is that the tribal courts are always at the tip of the spear of attacks upon tribal sovereignty. It is either the tribal judges or the tribal courts that are named in the Supreme Court as being unfair, abusing their jurisdiction, not having the right to do this or that. If you look at, and I could cite 10 cases right offhand where the tribal courts have been reviewed by the U.S. Supreme Court. So what we do is important. Sometimes our elected leaders and tribal attorneys don't remember that fact. But I'll tell you, I do. And I want to go over some of this so at least you have that a little bit of awareness and background of these issues. Let me begin also by pointing out that what we have now is a fairly restricted cases that we are able to handle as far as what we do regarding or compared to what we used to have. Like we said, in the old days, you know, they used to go out and decide to kill and take care of the monsters, literally. In 1896, the Muskogee Nation, and before I forget, what's today? The 12th? October 12th, 2017. For us as a Muskogee Creek Nation, today is the 150th anniversary of our National Council, our tribal towns, adopting a written constitution within the Muskogee Nation. 150 years ago today, we adopted a written constitution within the Muskogee Nation. We'd always had a government. We'd always had dispute resolution. We'd always had relations with other peoples. But we had converted to a written constitution 150 years ago today. That's, within that constitution, we specifically adopted a written form and recognition of our tribal courts. So we've had tribal courts, we've had courts in the Muskogee Nation for 40 years before Oklahoma came into existence and Oklahoma courts came into existence. We've been doing this for a long time, even in the form that looks familiar to the non-Indians. But in 1896, Timmy Jack at a New Year's Eve dance had gotten into a fight with his best friend and stabbed and killed him. He was arrested. Muskogee Nation courts convened a trial that had Muskogee attorneys as a defender and as prosecutor, and a Muskogee as a judge. It was all done, of course, in the language, Muskogee language back in those days. The witnesses, I'm Yuchi, the story I was telling you was Yuchi, and the Yuchis have been within the Muskogee Nation, are part of it for 250 years, 225 years. Our language is a little bit different, or is very different, but we're still part of them. The trial was done. I look at the witnesses. There were some of my friends and my old relations. They came back, declared it a mistrial because they didn't have the votes to convict. They retried him. They convicted him of murder and sentenced him to death, released him to wrap up his affairs and to return to Okmulgee, the capital of the nation, in 10 days. at which he did. He had requested that his friend, the Sheriff Okmulgee, was the one to fire the rifle and execute him because he did not want to have an enemy of his have the satisfaction of shooting him. And he was executed pursuant to the laws of the Muskogee Nation. Now, so we've gone all these types of different ways and things. We've got the traditional courts, tribal courts, courts that look like modern courts, but we used to deal with everything that was presented before us, up to and including death sentences. Now, today, though, as you're probably aware, for the most part, at least we have, when we're talking about jurisdiction, we're talking about three types of jurisdictions. We talk about personal jurisdiction, or the right to assert control over the people, places, and things, subject matter. What we're dealing here with is Indian law, that's a subject matter jurisdiction. People would be whether they're Indian, non-Indian, citizen of the tribe, non-citizen of the tribe. Places would be within our reservation, within our allotments, within our Indian country. Now, Indian country was a term that was used kind of broadly. What it means is those lands or areas which are set aside for use of Indians as Indians. It's not simply that one of us happens to own some property. Maybe we own a house in Albuquerque or Phoenix or LA or Denver or Chicago or somewhere else, Gresham, wherever it might happen to be. But rather it has to be land that we own or set aside for our use because of our status as an Indian. In that case, then we get into the Indian country questions, and we have all the different actors, whether it's the federal courts, the tribal courts, or the state courts. Now, of course, what's an Indian? That's the next question. And these are the types of things that we get into when we litigate in federal courts. But they do concern us to some extent, especially with some of the newer statutes. An Indian is a citizen of a tribe. Now, it's not, when we're talking amongst ourselves, it's common to hear us say, well, I think they're enrolled, but, they don't really participate. You never see them around here. I never knew they were Indian before, and I'd known them my whole life. It's the first time he ever admitted to ever being, Creek until he ran for office. I never saw him. But being an Indian under federal law means that you're a citizen of a tribe, of a recognized tribe. Whether you speak your language or don't speak your language, whether you know your traditions, whether you don't know your traditions, whether you have any of your ceremonies left or not, under federal law, it's whether you're a citizen of the tribe. Now, that doesn't even mean that you have to have any blood as of that tribe or of any tribe. Some of you may be aware that just recently the federal courts held that the freedmen have a right to be members of the Cherokee Nation. Now, the freedmen, back in the 1800s before the Civil War, several of the tribes, at least in the Oklahoma area, Indian Territory then, the Cherokees, the Creeks, the Seminoles, and I'm assuming the Choctaws and Chickasaws had slaves that they brought with, some of them brought with them from the east when they removed to that area in the 1830s. Not all of us did, just the rich, and mostly the what we called at that time the kind of ones who were part or half-breed Indians, that they called them back then, the richer Indians, but most of the full-bloods didn't. Nonetheless, there were slaves within those particular tribes. After the Civil War, they were, of course, freed. And in the treaties with the United States, those tribes, some of them, had said that they would adopt those freedmen into their tribe. Many of them, most of them spoke the language. Some of them, matter of fact, were in the Muskogee Nation. They even had a ceremonial town that they participated in their doings. But they had no actual blood of the tribe running in their veins. Well, just in the past 6 months, 5 months, the federal court said that because of that treaty, those people have a right to be within the citizenship of the nation. So technically, they are Cherokees, although they have no real blood in them. So they don't have descendancy. That goes to prove that it's a citizenship, just like if someone immigrates to this country, the United States, they can become a citizen. Even back in the 1800s, that occurred. The Chickasaws would adopt people into their tribe who had not been, they may have been traders, or they may have been working for the federal government and married into the tribe, and they're adopted in, they were considered part of the tribe. The opposite side is, back in the 1880s, there was a famous case, federal case, out of the Ponca Nation, I believe it was, where one of the Poncas, when they were to be sent south from Nebraska, I believe, didn't want to leave the homeland when they were being sent to Oklahoma, because he was attached to the place of his ancestors. So he resigned his membership in the tribe. This is 1880s. Well, the Indian agent tried to send him south, and they filed suit saying, no, he gets to stay here because he's not Indian anymore. The federal courts agreed. He said once he'd resigned his membership, he was no longer Indian, you couldn't force him south. So those types of things are still out there. That's why we get into it. Now, that also comes into play when you're dealing with the Indian Child Welfare Act of someone who is eligible for membership, the children, but are not yet enrolled. These types of things may come up when people are filing into your court as to whether they're Indian, non-Indian, citizen, non-citizen. How old are they? Are they under 18, over 18? So just give me a little bit of that, what we're talking about as to jurisdiction over people, places, and things. Make sure I'm staying mostly on my timeline. And I'll read you this. I'm trying to keep this so that I don't get into lawyer talk too much. If I do, just stop me and we'll back up a little bit, and I'll try to read. I've been doing law for 30 years, so I know I sometimes get carried away and I get excited and I just drop back into that jargon. Law school was only 3 years, but in 3 years they managed to completely change the way that you think about things, and it's taken me 30 years to unlearn what they've taught me. You know, I work with some of our ceremonial chiefs and people, and I listen to them, and it's like, all right, I've got to back up and unthink lawyer speak, and it's always a task. But it's unfortunately that's what happened to me. I'm sorry, I apologize. But anyway, in Justice Blackmun in one of the Supreme Court state cases said, and that's where they were attacking racial classifications, and this is something you may hear in the news, talking about how Indian child welfare is a racial classification and therefore we should just treat everybody the same. This is the United States. Everybody should just be an American. But Justice Blackmun said, the preference is not directed towards a racial group consisting of Indians. Instead, it applies only to members of a federally recognized tribe. This operates to exclude many individuals who are racially classified as Indians. In this sense, the preference is political rather than racial in nature. So, again, that comes in. We'll get into that in a little bit. Now, the tribes themselves, as we said, are recognized, and we get into where it comes into being. The federal recognition is in the United States. We're the only people, whether it's a citizen or racial, that are mentioned in the U.S. Constitution 3 times. We're mentioned in the dealing with us as Indians not taxed, as the Indian Commerce Clause regulating the commerce amongst the several Indian tribes, and the making of treaties. And of course, they don't make treaties anymore since the U.S. statutes have prohibited that. Congress said we couldn't do that from the 1880s forward. But we still hopefully have those intact. Now, I think I covered I mentioned, but I'll go back over that Indian country is the things that we talked about. Indian reservations, those were established, and of course we tend to think of those were established by usually presidential proclamation or maybe by treaty. That's what we tend to think of the big, Navajo Reservation, the Cheyenne River, Standing Rock Reservation, whatever it happens to be. But they can be fairly small, or they can be very large. Now, for us at Muskogee Nation, we were very excited. Oklahoma came into statehood in 1906, and everybody had assumed that our large 7-county reservation, at least the state and the federal government, had assumed that that had gone away, and that we were limited to just allotments, those lands which were given to individuals. However, in August, this past August, 2 months ago, the 10th Circuit Court of Appeals decided Murphy case versus, I can't remember the last name of it, Murphy decision, which said in a criminal case where a horrendous crime occurred down in, where was it, over by Wetumpka's area? Indian murdered another Indian, tortured him, mutilated him, and was tried and convicted, I think, death sentence in the state court. It was a long process, but over about a 10-year case, it wound up in the U.S. Court of Appeals for the 10th Circuit in Denver. And in a very long, very carefully analysis, those 3-judge panel just said that the reservation boundaries of the Muskogee Creek Nation were intact. So that even though 98% of the 5 million acres within that boundaries is now owned by non-Indians, the reservation continued to exist. So as it was an Indian defendant within that boundaries, the state lacked jurisdiction, and therefore it was being kicked out of state court and would be tried either in federal court or tribal court. That's a huge decision for us. It's not final because they have appealed it, asked for a rehearing in the 10th Circuit, and of course they may then, one side or the other, may eventually seek a resolution in the U.S. Supreme Court, and we don't know if we are successful there, whether or not, and how it will be attacked in Congress to undo it. But that shows that even though we kind of been going along very busily in our tribal court, limiting ourselves mostly to the allotments and to those lands which the Creek Nation has bought and owned directly and placed into trust, all of a sudden you can have these huge issues presented to you, mammoth issues. At the same time that happened in the 10th Circuit in August, I think it's the Wind River Cheyenne reservation was found to be disestablished. And so they are having the opposite problem that we are. So, although those don't come in front of you as clerks or anything else, I think it's to be aware of these things can come out and can affect you, and to be keep it in your mind. And of course, for us law nerds, we get really excited about that kind of stuff, especially when we win. We have so few wins in the federal court. Indians lose in federal court, usually. Not always, but usually. We don't like to go into federal court, which also means that it's really important that we know how to keep things out of federal courts. And that's why the clerks are the, not really gatekeepers, but hopefully you're keeping us judges out of trouble by, I don't know if you guys do it as clerks in your particular tribal court, but in every tribal court I've sat in, usually it's the clerk will sit on the right of me, and as we're going along and I'm listening and I think okay, I understand this, I know what's happening here, I think I know where I'm going with this. I'll see a little post-it note get handed across to it, and they'll say, you know that he's got 3 protective orders open against him, don't you? And you think, sir, is it true you've got 3 protective orders against you? And it's like, yes. I don't know where that came from, I'm just asking. So, we understand that there's things that keep us out of trouble, and if you are a smart judge, you realize how fortunate you are to have good clerks. But as I said, that's the kinds of things you never know, and so it's good to be aware of that type of stuff. I'm trying to keep an eye on it. I know that Ms. Donna is anxious to be over there. I'm going to pay for this. I had prevailed upon her to do it. She was reluctant. But I really do, I know that she has a lot of experience, and really looking forward to her presentation again. Now, A couple of the things that are going on in the broader terms. Of course, I don't know where you're sitting. I don't know where your courts happen to be. Maybe you're in California or Washington State, or is it Idaho that has PL 280? Or maybe your court's a general jurisdiction, or maybe you only have certain things which the tribal legislature has vested over into yours. Many of us are courts of general jurisdiction, which means we get to hear anything that somebody files into our court. PL 280, for those of you who are either aren't familiar with it or have not, who work with there but don't have the background in particular, back in the 1950s, as we said, the federal government was trying to get out of the Indian business. They wanted to do away with tribes. That's why that period of termination, that's when they were sending a lot of our people from the reservations. The federal government, the superintendent would pay for them to go to Los Angeles or Chicago to live. They'd pay them bus money for the family. They might even give them 90 days living expenses and dump them in those cities. And that's how some of places like Denver, Los Angeles, Chicago ended up with such large Indian populations directed from the 1950s forward, removing them from the reservation. Because if you got rid of the Indians from the reservation, from an Indian country, you got rid of the Indian problem, according to the federal government's thoughts. Along with that was the decision, in part, that we were going to get out of the tribal court business and put those into the state courts. So PL 280 said that the states could either assert or were the only ones that had criminal jurisdiction and or civil jurisdiction over matters within our tribal territory. And we're still dealing with the consequences there of that. Some tribes have been able to get out of it. Some of the current legislations allow us to get out from under it in certain types of cases. But it's still there. Now, the federal government got into the Indian court business back in the 1880s. Many of you have heard, or maybe you've heard in passing, the Ex parte Crow Dog was a famous U.S. Supreme Court case. Crow Dog was a Lakota man living on, at that time, the fairly large Sioux reservation, and he killed another Lakota man. And under Lakota law, as I understood it, traditional law at that time, there were certain things which were to be done. It wasn't so much punishment, as I understood, but restitution and restoration. I've heard some different stories about the details, but nonetheless, under Lakota law, the parties were satisfied with what occurred between the defendant and the victim's family. But the U.S. attorney and the Indian agents, the federal Indian agents at that time, weren't happy because here's a man that committed murder and nothing happened to him. He's just going on with his life, what they thought. So they tried to file criminal charges in federal court against him. But the U.S. Supreme Court said at that time there's nothing which gives jurisdiction in the U.S. courts over Indian crimes. In response, in 1886 or 7, they passed the Major Crimes Act for Indian country, which created, I think, originally 8 or 9 crimes, 10 crimes, which included rape, murder, assault, mayhem, that type of stuff. It's been expanded slightly, or greatly, and that's why now you see prosecutions over in the federal courts for crimes, serious crimes in federal courts. Now, between 1885 and 1887, when that occurred, and 1936, when some of you are familiar, 1934, when our tribal governments started, some of them, reorganizing under the Indian Reorganization Act. We moved from having our large reservations, our traditional governments, whatever methods we used for restoration, whether it was all the animals meeting together in council to discuss it, or whether it was like the Muskogee Nation where we had jury trials to execute. We had our own ways of resolving disputes. But as everything else was being suppressed, destroyed, removed, and to be quite honest, if you think back about what was happening during the allotment period when our reservations were broken up and destroyed, in a period of 30 years, you could see your entire way of life destroyed. If you think about the impact that would have upon you if you thought everything you know is just changed 180 degrees right now, how many of us would be able to have the strength to resist drinking, abuse, physical violence, all those other problems that come into play? So our societies were really being in trouble right when we needed our own resolution methods the most. Instead, what Congress did and what the Bureau of Indian Affairs did was create courts of federal regulations to hear and to settle matters in a way that they knew white people would do. And so these court of federal regulations came into existence for the tribes. Or simply the white superintendent who had grown up in Detroit, New York, wherever else, came to the reservation and would decide the disputes and everything else within that territory on his own. I don't know how active the first thing I have seen tribal courts really becoming active was in the 1940s in Hopi and Navajo. They may be some of you. Do any of you know if you have a tribal court that existed before 1940? In the 30s, 20s? Any of you? If you did, just raise your hand. Any of you aware of it? How about the 50s? Do you remember if you have tribal courts, your tribal courts start in the 50s? Any hands? 60s? Okay. So you see that in the 1960s, we started resurrecting our tribal courts. And we're still in the process. We still have to fight that out. And we're still trying to get jurisdiction back over to our tribal courts. So anyway, now we're moving forward. We're beginning to get these tribal courts. We're starting to assert jurisdiction. We have our own people doing these things, but even though it may be patterned on a white man court, we have at that originally started to doing them things just the way we understood them if we had our own people doing it, the judges and clerks. Now, as I said, the last man that I know was executed pursuant to Indian law, and there may have been others, I don't know, but 1896 in the Creek Nation. After 1896, I have not seen any reports of another Indian sentenced to death by a tribal court, period. There was nothing under federal law which prohibited that to occur after that. Now, in the Muskogee Nation, Cherokee Nation, Seminole Nation, Chickasaw, and Seminole, and we're just talking about those 5 tribes, the tribal courts were recognized by the federal government as being such a threat to the actions that the federal government wanted to do in regards to the tribes as a way to get the tribes accepting allotment was to get rid of the tribal courts. That was a conscious effort by the federal government to destroy the reservations by getting rid of the tribal courts. Some of us resisted longer than the other tribes, and that's why our tribal courts in the Creek Nation, by statute, ceased to exist under federal law in 1906 and went away. And we fought for 70, 80 years to finally have them reestablished, and we were successful. But other tribes, that never really happened. They just kind of went away, whatever the traditional systems are. Now, some of you may have continued to have traditional dispute resolution. I don't know what happened. Maybe the state courts were intervening. All kinds of different procedures were happening. But in 1968, as we know, the 60s, one of the big things with the civil rights was getting active. They passed the Civil Rights Act of 1967, I believe it was, that had the Voting Rights Act and so forth for Martin Luther King's actions. Interestingly enough, the Indian Civil Rights Act of 1968, which kind of tracks the United States Bill of Rights in the first 10 amendments and says that Indians have these rights to freedom of expression, has a right to freedom of religion, rights to attorneys and things like that, and criminal proceedings, due process, everything else. Although it does not say you cannot have an established religion. Some of our tribes have, and still continue to have, the religion which is directly involved in the tribal government. So they pulled that out. But one of the things in that act said that tribal courts may only sentence someone to a period, and this is 1968 Indian Civil Rights Act, a period of 6 months and $500 fine, maximum. Before that, I think a tribe probably could have done anything they wanted, but as of then, under the federal law, it was very, very limited. Some period after that, and it wasn't, I don't think until the 80s that they amended it up to saying that we could impose a sentence, jail time of 1 year, still up to 1 year, and $5,000. I was telling people yesterday in the tribal judges portion that when I was working at SAC and Fox and we amended our codes, it was extremely frustrating because we would have people who had committed assault, battery, rape, attempted homicide. Sometimes we could get the federal government to intervene and prosecute in federal court, sometimes not. There's lots of things. That's a discussion for a different day. I know that you other tribes have that same type of issue of good relations or horrible relations or inaction on the federal prosecutions. But we could only impose a sentence of 1 year at maximum, and it would be the same whether they simply got drunk at the powwow or whether they attempted to murder someone. It was the same sentence, maximum. That was disheartening. We amended that code. We took advantage of something that came later, back in 2010, the Tribal Law and Order Act, which says that now if you do certain things as a tribal court, you can impose a 3-year, and $15,000 fine, up to a maximum of 9 years incarceration for separate charges. Now, I'll get to the details of what that involves here in a moment. I'll cover very briefly. But I will also let you know that in 1978, some of you are familiar with Oliphant versus Suquamish. The federal court said that we could not prosecute non-Indians. And so although we have all these people who are intermarried to our tribes, come into our tribal territories, if they do something, we're without jurisdiction over them, supposedly, under the federal courts. The Tribal Law and Order Act said that we can now prosecute at least Indians up to 3 years. In 2013, which is 4 years ago, the Violence Against Women Act, which some reauthorization, allowed us under, again, if we take advantage of the Tribal Law and Order Act provisions, we can now prosecute non-Indians for certain crimes if they are domestic abuse, violation of protective order, and I think it's sexual assault, if I remember right. I can't remember what the third one is. We've adopted it, but you have to track the same, basically you have to track the same processes and provisions as if you were prosecuting somebody in federal court. There has to be a law licensed attorney provided. They have to be provided an attorney if they can't afford one. If you don't, prior to that, if you don't take advantage, you don't have to provide an attorney if they're not being prosecuted for more than 1 year. But under these, you've got to provide an attorney if they can't afford it. Has to be law trained. You have to have a court of record, so you have to keep proceedings on record and so forth. You have to tell them their rights. They have an automatic right to file a habeas or a review in federal court, and so there are several other things. So you're trying to look exactly like you would in federal court. And that's a sticking point for some of us, because we're tribal courts, we want to do things our own way. And the more that we look and act like a federal court, a white man court, the more we are a white man court. And that doesn't sit well with a lot of people. The other thing is that the juries have to be comprised of a cross-section of your community. And that means you have to have non-Indians on it, basically, if you're drawing from them. And that may be something we have to think about at Creek Nation now as we expand our jurisdiction under this Murphy decision. In other words, if you have non-Indians working for you or living on your territory, then they probably have to be in your jury pool. How you get into that, how you decide that, is things that we've wrestled with Muskogee Nation, Sac and Fox Nation, the other tribes I've worked with. They use different procedures to get there. So there's a lot of things that you have to be aware of that don't affect your daily course cases. Let me see, the one last thing I wanted to get into, though. As I said, we have now gone to where and it's only 12 tribes that have taken advantage of this VAWA, Violence Against Women Act, Special Criminal Jurisdiction provisions, so that they can charge non-Indians who commit crimes in tribal court. We at Creek Nation, I don't think we've had any charged against us. A couple of tribes have been very active in doing this. They've had, I think that the tribe just south of Phoenix has had quite a few prosecutions. And the most remarkable thing for those tribes regarding their non-Indian prosecutions is that there's nothing remarkable about it. It has occurred and proceeded just like any other cases they have. I mean, I don't think that most of us who work in the tribal courts are surprised about it, but the outsiders seem to be stunned that we can be fair and act like we are actually tribal courts. But we have at least cracked that door. My understanding is that there are some proposals coming into Congress in the next week or so to expand that to certain instances, which would include crimes against children and maybe some other small provisions, which I think that if you can find out the details, it would really suggest you get your tribal leaders to get behind it and support, because I know that most of us deal with children, and if you have kids in your home, there is no telling if they're Indian or non-Indian. You may have a daughter or granddaughter that's married to a non-Indian. They may have children, stepchildren. Maybe they're tribal members, maybe they're not tribal members, maybe they're Indian, not Indian. And so something's happening in that home. We can go in and take up the two little Indian kids, but we've got to leave the little white kid there, or Mexican kid? No, I don't think so. This would resolve that problem. This is not anything new that we're asking of them. The treaty with the Wyandot, Huron, Sac and Fox, which was from what we call the Fort Harmar Treaty of 1789, one of the very first treaties entered into by the United States. Article 9 of the treaty between the Wyandot and other Indians and the United States. Article 9. If any person or persons, citizens or subjects of the United States, or any other person not being an Indian, shall presume to settle upon the lands confirmed to the said nations, he and they shall be out of the protection of the United States, and the said nations may punish him or them in such manner as they see fit. If that does not give us jurisdiction over non-Indian, I don't know what does. There are several treaties like that. Of that early period, the Delawares had one. I think the Creek Nation had one also. There's some other tribes I'm sure that did. So these things do impact us. I just want to give you as a background as you're dealing with your everyday affairs. Hopefully this computer is still on for our presentations. We'll see what happens. I think we've got through all the boring stuff. I apologize. I'm going to turn it over to Ms. Donna, our court clerk at Muskogee Creek Nation. Any questions before she gets into it, or do you want to wait a little bit? Computer's up, but we don't see our connection.
Did it go? Do you have a PowerPoint, or is that mine? No, that's mine. Okay, let's see. Hold on. Let me just. Okay, we'll pop that out just to wake it up. See what it's gonna do. Did it pop up?
That's to the end.
That's his.
No, that's mine, but it's to the end.
Whoops. Sorry, I don't know where that went. Oh, is that it?
That's the website here.
Went to the website.
Huh. Well. Here, I'll go this up to the front, so there. You can see him on the left. We'll try to get the, her PowerPoint up on the screen. She has it for her.
Good morning. Well, hopefully we'll get this up so you can see what we're going to talk about. I'm going to try to discuss moving cases forward, not from the perspective of the clerks so much, but by dealing with the attorneys trying to move things forward, or pro se litigants. And this is more of a discussion, so if you have anything to add or any questions, please ask, or if there's any problems that you have in your court, please share them. Well, we've just lost our PowerPoint, I think.
Yeah, you can see that, all right? You just-
That's not mine.
Oh, isn't it?
Mm-mm.
Do you have yours? I can get you mine then.
Okay, I have it. Well, I'll try to talk more about what you were going to see, but in the Muskogee Creek Nation District Court, I had up our laws and our codes, and you can apply those to your tribal courts, but it's something that, you know, we have to be aware of and look at, and if it changes, if it's organized or reorganized, you have to follow those. And I think they're coming up. Maybe we can get those up there. That's not mine.
Not this one, the other one. What do you want?
It's that introduction.
This one?
Is it up? Coming up. Okay. Good deal. Okay, you can see what I was talking about earlier in our laws. Now, this is our code that deals with the court, the judicial branch, and it shows how our district court is organized. We also have an appellate court, which is our Supreme Court, and it just is an example of showing our organization of our court. Where this clicks. There we go. This is an example of our case types that we do. Yeah, he passed it. And we deal with pretty much all types of cases, except we don't file probates in our court. I don't know how many tribal courts do that, but in Oklahoma, they are still filed in the state court. And this is some of the other things that we have to, the clerks are responsible for, is we also do marriage license in our courts. We have bail bondsman's license and process server license. And we also, another thing that we deal with in our court is attorneys have to be licensed through our district court, through our bar association. If they are not, they can't file cases, they can't appear in court for our hearings. And most of the things that we file in our court are from attorneys, We do have some pro se litigants, but not a lot. We don't have forms like they do in state court for divorces and that type of thing, so it's, most of the time, it's attorneys that do the filing. On the case flow, you can see that, again, that's our code and our laws and how they're filed usually in all tribal courts, and the clerk deals with the same thing, the petitions, the summons, the return of service, motions and applications to set for hearings and orders, and that's a difference that you have to deal with sometimes in state court and tribal courts. A lot of state courts have motion dockets. Some tribal courts don't. We don't have motion dockets. We set hearings, we set motions, but we'll use notices and orders that's setting it. We don't have an automatic docket that is set every month. Some attorneys don't realize that, so you have to make them aware that you need to do an order or a notice of hearing to get those things moving forward. Some things that change, I know we had a reorganization in our court. We used to have one full-time judge, but we now have 2 judges. We could have 3, but at the present we have 2 judges. It totally changed how we scheduled cases. We used to have a judge there every day. We could have cases filed every day. Now our family division is only there twice per month, so you have to deal with, the attorneys getting getting their cases filed and getting them moved forward with the judge's docket, which a lot of times they don't like that. Another thing we deal with in service for our court, we have our light horse police that does service for us, and we also have private process servers. The other thing we deal with for attorneys is that they have to be licensed through our court. Again, they can't just go pick a process server out somewhere that they use in state court unless they are come and apply for their license in our court. We do have fee schedule. We try to keep that on our website, which we do have it at this time. And another thing, our fees are different than in state court. So you'll have to make sure that they know and are aware of all of the things that you have to deal with for that. The jury trials, we have juries, we have jury trials, and ours is picked from registered voters of our nation that live in our boundaries. And we usually have 2 terms of court for jury is twice a year in the spring and the fall. Sometimes we can have more if we have to, like if we have people in jail that we have to have a trial for. But again, that's part of the thing that you need to keep up with your laws and your codes. And even though we never give legal advice, we have to keep up with that because it affects how we do our work. For instance, in our court, we had a change on how you pick a jury. We used to pick from the registered voters, but with VAWA, that changed. So now we have to have a separate for them, and as what we're doing in our court, we're picking from employees of the nation. There's non-Indians, there's non-citizens, and so you had to change your whole jury process of how you picked those. And the other thing is on VAWA is the protective orders, they changed. So you have to keep your forms updated. You have to realize that some of them changed, don't use them, your old ones. If the law changed, keep up with what's passed and what comes down that affects your court. Because like in ours, the time limits changed. It went from an emergency order being good from 10 days to 15 days, a final protection order being good from 3 years to 5 years. And if you work on jury instructions with your judge or verdicts. That's a big change too. You have to keep up with the laws. The Tribal Law and Order Act changed that. So we had to be sure that, you just don't go back in and use some of the same forms that you do, that you had in the past, because that also changed some of your instructions, your time limits, your sentencing. And we deal with court appointment cases for indigent defense. And they have to be members of our bar association. We used to have a contract indigent defense group. The laws changed on that. That was another thing that affected us. We had to start choosing attorneys from just the bar list that had requested to be court appointed, and they have to go by our guidelines. Those are also on our website. And we have forms on our website. We have small claims forms, garnishments, foreign judgment forms, and dismissal forms, among some other things. And we are updating our website. You need to continue to update your website if you have that information on there. And what information we can get out to the attorneys is more helpful to us to be sure that they do what they're required to do for our court. In our court management system, we have full court. We went through some changes and upgrades, so we now have site pay. We can take payments for our fines and fees by online payments they can get into. We're going to be doing credit card payments shortly. And we've brought in a lot more revenue by doing that just in the last few months that we've been doing that. Some other tips that we have as court reporters. We don't have, and I'm sure a lot of your tribal courts don't, we don't have a court reporter that is on staff. So for certain trials, and it's according to our code, we have to provide a court reporter for those hearings. Otherwise, we have recordings that we record to keep the record for everything. Process servers, that's one of our problems, to be sure that they have the right process server. So we try to get that information out to them. Also, bail bondsmen, we have that problem of they'll try to use a bail bondsman to get somebody out of jail that isn't licensed through our court, so we'll have to be sure that they do that. And another problem we have, and I'm sure most of you have, is on our final orders and decrees. We can't get attorneys to file them when they're supposed to. So then you have the problems of dealing with the customers coming back several years later wanting a certified copy of their decree, and we've never got it. Garnishments in our court, they have to be filed through our court. If the original judgment wasn't filed, they'll have to file a foreign judgment. That's other information you have to get out to the attorneys to be sure they know about. Other problems, proof of service, they don't return it. We can't get judgment by default if it's not there. And I know some of the differences that we deal with in tribal courts. I worked for state court for years and then went to tribal court. We deal more with our customers, more with the citizens, and more with our judges. So we have to be able to know how to give more information to them without telling them how to do the process, how to give legal information to them without giving them legal advice. So those are just some of the problems that we deal with, and how to deal with it by getting the information to all the attorneys and the other process litigants. So I don't know, is there any questions or? Do you have anything to add, Judge? I think that's all.
Any questions? I apologize, I know that the technical difficulties made it a little bit hard to follow some of the presentations, so we apologize for that. But I think that, of course, each of your tribal courts probably have a little bit different process. We wanted to show you what we had for representation. Maybe some things you do have, or most of them you have, maybe some of the things you don't have. I think that the thing that tribal courts wrestle with the most, I know we're almost out of time, is the question of how much advice do you give, or how much assistance do you give to the tribal members. And that varies a lot between tribal courts from what I've seen. I think that ours, we try to be helpful, but because of the volume of our cases, I don't think we provide as many forms of the other things as some courts.
All right, thank you.
All right, let's give the presenters another round. They did a good job. They've been doing good this time. All right, so the only other thing is if, I'm not sure if you got the evaluations. If you got the evaluation, then go ahead and fill it out. For this session, I think you got some for the other ones, but I'll double check and make sure. So.